Hi, thanks so much for attending. I'm Gary Forster and this is Brian Page. We have a corporate tax boutique in the Orlando area. We do corporate tax and international matters. And today we're going to talk about cryptocurrency and taxation. We're also going to talk about several asset protection and general international tax matters, which blend nicely with the cryptocurrency topic. We've spoken many times on the topic in light of the fact that the CPA community has had a significant uptick in these transactions and has shown a lot of interest in the topic. So I'm going to turn the first part of the presentation over to be narrated by Brian. So go ahead, Brian. We'll start with the agenda.
Thank you, Gary. So we'll start with the agenda. We'll start with how blockchain works, what it is, how it operates. And then once you have sort of a foundation with that, then we'll move into cryptocurrency in general, what type of asset it is, what it can consist of, how you acquire it, how you dispose of it. And then on top of that, once you have that, then we can go into how it's taxed and regulated by the federal government, both at the on the tax side, but also with the Financial Crimes Enforcement Network, the SEC, the FTC, and there's a lot of compliance with this unique and new type of asset. Then we'll get into the compliance side of, if you have a client that comes into your office and they have this type of asset, they've either acquired it or disposed of it or exchanged it, what does that mean for you practically from a reporting standpoint to the IRS, what forms to be on the lookout for, what to be thinking about, and also the informational returns depending on where the assets are located, you might also have to file for your client. I will then turn it over to Gary, and he will discuss asset protection trusts and their relation to this type of asset, how those would be taxed, and then the uses of this type of asset with the asset protection trust. And then we'll end that with some questions that you might have.
There's a lot of material. We'll try to pose, as we're recording, we'll try to pose some of the questions typically raised on the crypto and on the asset protection / tax side. So we'll also present at the end our contact information, just in case you have any questions you'd like to present, and we make ourselves available to the CPA community. That's really our main contact point with respect to our business.
All right, moving along. So the main question, I'm sure you've heard about it in the news, you've read about it. What is blockchain? Well, it's more than just cryptocurrency. It is a network in the cloud that stores information, and it can be from anything from something like Bitcoin, which is what we'll be talking about today, but also with smart contracts, with record keeping. There are some recorders around the country now that are now storing their information instead of having a book like you would have at in the archives. They are using this technology because once it is utilized and a block of information is put on the chain, it cannot be changed.
Well, it's also like a corresponding benefit to these cryptocurrencies. So we've had a lot of activity with cryptocurrencies lately, and the idea of this money is one issue, and then the other issue is how are transactions with the money recorded. And so there was this invention called this blockchain, whereby each transaction is confirmed as valid within the blockchain. It's a validation system as much as it is a currency. So this validation system can work not only with currency, but in any kind of chain of information type format. And that's what's happened, is that idea of this blockchain applied to a number of different scenarios has really become the benefit of the cryptocurrency rage. So we're going to go into how you're treated, how you're taxed with respect to cryptocurrency. But this blockchain idea and this validation system, it's currently anonymous, but that's not necessarily the case. If, like, for instance, a government uses a blockchain, it'd be very, very easy to determine who's involved in each transaction. But this validation system's really become one of the benefits of cryptocurrency and one of the reasons it's taken off.
Right. And what's interesting about this technology is that it's been around from, I believe, 2009 is when it started. But it's never been hacked, believe it or not. And now we'll talk about there have been some exchanges where people have stored their wallets that hold this asset. Those have been hacked. Mm-hmm. But the actual technology itself has not been hacked. And once something has gone through the process and has been confirmed with an algorithm and solved, that chain cannot be changed. It's forever imprinted on the blockchain. So that's an interesting technology. And so our government and governments around the world have operated to try to catch up and to apply regulations with this asset, especially on the tax side, because the idea being that the government is not involved with these financial assets. There's no borders. There's no central government that is controlling. And now there are some governments now that are talking about, including the United States government, having their own. But at this point, the main ones, and throughout the slides of today, we will say Bitcoin, but we mean basically any type of cryptocurrency, but it's the most common. So that's what you'll see throughout the slides. That's what we mean. With cryptography and the ability to have this problem being solved, it enables that technology not to be hacked. So it's really fascinating. And we're trying our best to keep up as it develops. But the main thing on the currency side is that there's actually a public ledger, and you can go on and log on to, there's Bitcoin, there's Ethereum, there's Ripple, there's Dogecoin. There are so many now. You can actually go online and see them, sort of like the Matrix. You can see the keys and the amounts and who's doing what at any time. But unlike a bank account, you have a public key and a private key. The public one allows you to trace where these assets go, but you don't know who owns them. That's on the private side, unless they disclose. You'll have some charities now that say, "Hey, this is my wallet. This is me. Please donate." But beyond that, it's pseudo anonymous.
Oh, I don't think you need the private to donate.
No, you don't. Yeah. You don't, but they'll.
Oh, that's to confirm it's them.
Right,
to
confirm it's them. Mm-hmm. Yeah, that's why. Because otherwise, once you make a transaction, it's gone.
It's gone. Right.
So, but anyway, it's really fascinating, and so we will get into some questions and some things. But on the whole, cryptocurrency is decentralized, at least as it currently exists, which means that there's no national government or bank that controls it. With any banking transaction, the bank is the intermediary, or the credit card company, or whatever. So you have a vendor on one side and a customer on the other.
And with tax, and many times you have a withholding agent.
Right.
So that's why it's really been looked at so carefully, so scrutinized, because the reality is, if you don't use an exchange, obviously we've seen the exchanges now being investigated by the IRS and reporting to the IRS. If you don't have an exchange, you don't have to be on an exchange to buy Bitcoin, for instance. There's no way to know. There is no disclosure in the system where the IRS could take a look and figure out who that was who just sold that Bitcoin.
Right. And so, and as we'll see when we get into the taxation, this is important by the nature of this type of asset, how it's being governed, and what we have determined on the US side, at least, at every level of disposition, there's a taxable consequence.
And also for the CPAs, it's also fractionally, it's also a tremendous attraction to criminals.
Right.
So you have to be very careful. We've had a number of criminals come in. We don't do any business with criminals. We don't even do fraudulent transfers. We don't do anything that would at all sully our reputation, but we have seen a disproportionate amount of shady people involved with this Bitcoin, something just to keep an eye out on, not necessarily the case with respect to your clients in light of the fact that many people are buying and selling this stuff, but in terms of people focusing on it as a sole asset or as a sole means of operating a business domestically or offshore, just be on the lookout.
That's absolutely right. It's also, interesting is that if you do a transaction, let's say, and it's peer to peer, or once you make a transfer and it doesn't work out, you can't change it. There's no governing authority to go back and claw something back.
Right. And if someone dies with the private wallet and there's no way to know the number in the wallet, then there's no way to access the blockchain and the money's gone.
Right.
It's something to keep in mind.
The other thing is, as we already discussed, it's a secure type of asset. It's verified through algorithms on the cloud, and then of course, once the cryptography goes through and the computer solves it, and whoever wins that gets paid. That's what mining is, and we'll talk about that. Once it's done, it's immutable, cannot be changed. So if someone steals it and then they move it, it's gone.
Oh yeah, it's gone.
So it has pluses and minuses.
Mm-hmm.
There's no intermediaries, which there's no central body. There's not one place where there's like a server and that's where Bitcoin is, or any crypto. It's all over the place. And so, a government just can't go in and like get rid of it, shut it down in one location, which is, good and bad, depending on type of government. It can be exchanged, and that's really what, this is a medium. If you think about certain countries around the world, the idea being that there are some that you cannot trust the currency, the governments, the banks, and so this allows commerce to occur on the positive side without having to deal with the borders and the banks and the bribes and things like that. On the negative side, as Gary talked about, it's a big deal for folks on the dark web, criminals, drug dealers, all those types of things, because it's not governed.
It makes it very easy for them in some ways.
Right.
Well, it's not just not governed. It's totally anonymous. It's
right.
a number. It's a number.
It's
governed.
It's governed, right? It's governed, but it's not governed by a government.
No, body. But it's regulated, but there's no way to figure out what people did if it's
right. And then it's gotten to the point now to where, because now they're able to, within with exchanges and all, these national governments, the NSA, CIA, Interpol, FBI, they're able to, from a point they can trace things, but now they have what are called mixers, which you pour things in, it spins around. When it comes out, you can't track it anymore.
For your coin.
Yeah. So there's, do all these different things, but it's pretty interesting. It's not 100% anonymous. It's pseudonymous, in that, think of it like a postcard, or I should not call it like an envelope, where you can see the address on the outside where it's headed to, a public wallet or a key, but you don't know who owns that key.
That's the problem. That's right.
So, they can trace where things go, but they don't necessarily know who owns it. And so that's why it has the anonymous factor, which a lot of individuals like. And you'll see the clients that think, oh, the government will never know about it. It's anonymous. Well, that's not quite true. And they also have a duty to make sure that they, even on the informational side, if they just acquire it and it's not taxable, now they're on the 1040, there's a box to check that you have this type of asset. It's sort of like a foreign asset, basically. And it's just informational. And that's how the IRS is trying to keep track of these things. So what's interesting about the majority of these things, these coins have a value, but the value is only what an individual will pay for it to get it. So unlike a fiat currency from a government like the United States dollar or the euro, these things are exchanged and they have value, but it's only based on what someone will pay. And that's why you have such volatile fluctuations of value for these types of assets, but they do have value.
Yeah, that's a different question.
That's true.
But it is very relevant because they're not taxed like foreign exchange. And Brian's going to get into the taxation now.
Right. Then, of course, we talked about miners. Miners are the individuals or businesses that use their own computers or processing to solve these algorithms. Every time that there's an exchange, someone buys something, or there's a transfer, it goes up into this cloud, and then somebody has to solve that to make the blockchain the next part of the information. And whoever solves that gets paid. And that's what the miners are. And they're paid with that currency generally, depending on what it is. So Bitcoin, or, and then lastly, as we said, it's borderless and is international. So, it's not just in one place. So it has, like I said, positive and negatives. Okay, so that's a broad overview. Now we're going to talk about practically for your clients, how do they acquire these things, and then what does it look like? We talked about a wallet. A wallet is a place that stores the private and public key. Think of it like a safety deposit box. You need both keys to access what's inside the box, which in this case is the asset itself, the Bitcoin. So the public key is like an email address. Basically, it's where you want to send a Bitcoin. If I want to send one to Gary, he would give me his public key. I would put that information in, and then it would then send it. So that's how that works. The private key, which is the main thing, that's your password to access the value that authorizes the transfer of the asset. So if you go to Bitcoin, and I recommend that you all go there just to see it, I would go on there and make your own wallet. It doesn't cost any money. You can see what we're talking about. And these are all these types of assets will have this. You'll have both a private key and a public one. And it's this long number. I'll show you an example in a little bit, but that's how this operates and how it works. If you lose your private key, you can't access the value anymore. It's gone. So you want to make sure, and that's also why it's important if someone steals it, it's sort of like a bearer bond. Once they get it and they move it, it's gone, and you'll never see it again. So passwords are important. And so there are different types of wallets. You're able to have, printout, which, there are some individuals that do that, but it can be stolen. You can put it on your desktop or laptop, but then what happens if your computer crashes or someone steals it? You can use the web or the cloud, but then you have to, worry about it being hacked. Even though I guess Microsoft 365 is good and some other ones, you still have to worry about it. If anyone gets access to your private key, they can access the funds you have no matter where it is. So it's important to make sure you save this in a safe place. Others use mobile devices. And then lastly, a lot of the individuals will use their brain, but if you die, it's gone. So we can't, emphasize enough, this information is very important. It's vital. We've had clients or estates where an individual had all this stuff and they died and they couldn't find the information. And so the value is just out there and they can't access it. Maybe one day they might find it, but if not, they can never get the value. So it's important your clients know that they put this information in a safe place, and if something happens to them, their family members or loved ones can find it and utilize it. Now, how do you acquire them? When this first started, it was peer-to-peer, which is, people of my generation, we grew up with Napster and LimeWire, these music things, and the idea being that someone would have it, you would connect with them on the internet, and then peer-to-peer, back and forth, you could exchange things, a value, barter, or whatever. That's how it started. And, an example of that is a platform is localbitcoins.com. Still exists, but the problem with that, though, is that if you're always worried about trusting the other side, exchanging whatever you're going to exchange. So then you get into what's an exchange. And that's where the majority of these things now occur. The big ones are things like Gemini is one of the main ones. But you're into the intermediary again. It's sort of like PayPal. You're using this third party to verify things. So you kind of have gotten away from the idea of what Bitcoin was, which is to avoid an intermediary. But you want to be safe with what you do. So if you want to acquire one now, if you want to acquire a Bitcoin for cash, US dollars, you would likely go to one of these, you would open a wallet, you could then go and exchange US dollars for cash, and you would pay the exchange a fee for the service. And then lastly, if you want to, we've had clients that want to create their own, type of currency, then you would have an ICO, initial coin offering. We don't advise this, but some individuals want to do it. The SEC gets involved now. It's a big headache, but that's another way to, when an individual opens one for the first time, you can go acquire it at an ICO, sort of like a stock offering.
Mhm.
So Bitcoin. So this is sort of a diagram that shows how it operates. So you use your computer or your smartphone now. You go to the website to wherever it is, and you open a wallet. And you see an example there of a code that is a type of public key. It's just an example. It's long, and you'll have one that's like that as well for on the private side. You'll need those two things to access the currency. You will then put some money on the exchange. You'll buy the asset, and then you'll have your currency in your wallet from then on. That's how it works. And then likewise, if you want to sell it, depending on how it's done, either you will exchange it for value, you'll exchange it for other types of cryptocurrencies, or you'll just cash out for cash. So now, regulation-wise, how has the U.S. government responded to this thing? This is actually a very unique type of asset, to where all of the federal bodies that regulate things consider it a currency.
Mhm.
So a convertible, a virtual currency, which is subject to regulation. And so the Financial Crimes Enforcement Network, FinCEN for short, they issued this guidance in 2013 saying that yes, it is a type of currency and we can regulate it. So all the, money, start off with the anti-money laws, AML laws first. That's where they started it. And then along with that came know your customer stuff information. So if you open a foreign bank account or anything like that, you have to fill out these forms. This allows them to get the information and to make sure there's not nefarious things going on. Then if you transmit these things, there are money transmitter regulations that are involved. And then finally, if you're in the business of doing it, you're a money services business, MSB. And then that is how also there's both federal and some state regulation with that. Now, the reason they have all this is because of, the drug dealers, the terrorists, they were using these things. And so this was a way for them to put them behind bars and to stop those types of transactions.
It puts it in the net if they can catch them.
If that's right, it's a big if. So that's how they treat it. And of course, the SEC and things like that, they have their own ideas of how to treat it, but it's very much like currency or stock. The IRS, though, said, you know what? We're not going to treat it like foreign currency. Instead, we're going to say it's property. Well, that has major tax implications because every time that there is a disposition, that means it's taxable.
Yeah, it's not exchange of currency, which has special rules and benefits. So even though the regulatory bodies want to regulate it like currency, the IRS wants to tax it immediately.
And every step too. It also, if you think about it, it also discourages its use because at every level you're having, it's a taxable event.
Right.
So then you'll just exchange it for US dollars or euros or whatever, and then they can tax that and trace that, withholding, all that stuff. Now the first notice from the IRS, it came out in 2014. That's IRS notice 2014-24. Still valid. It still governs a lot of the things that exist. They have refined it a little bit since it initially came out, but it's still there. We recommend that you go there and read it. In 2019, they gave additional guidance in a FAQ, and that was on October 9th, 2019. I think there are 45 or 46 questions and answers. It really gets down into factual things. Before, the IRS 2014-21 was more broadly treating it like property, but the FAQ was more, you have this fact pattern, this is the result. So definitely,
that's not a binding, by the way, a fact. That's
Right.
just their position.
Right, and we really don't have that many cases yet that really quantify how the tax court will look at it, but you can rely on what the IRS says from the perspective of that's what they say and that's how they'll treat it. So definitely recommend that you go there and take a look at it. Now, that being said, there are some basic questions about, this type of asset. Number one, how do you account for tax basis? We'll talk about that. We'll talk about, is it subject to like-kind exchange treatment? There was a bigger argument about this before they changed the tax code about, I guess it was 3 or 4 years ago. Now we know for sure what the answer is, and just a spoiler, the answer is no.
Yeah, surprise.
Surprise. You can't do that. Now it's just investment property for real estate. That's 1031,
like, just real estate.
82. Yeah. If you hold it in a foreign exchange, do the FBAR requirements and foreign account requirements apply? Because most individuals they think, oh, I'm going to have it offshore. And most exchanges are set up offshore because they don't want the regulation from the U.S. That's where they are. Then of course you have the FATCA if it's offshore. Is it a security or commodity or neither, as it relates to if you're in the business of, or if you exchange it and you lose money, the losses? How does that work? Is it passive if you want to take loss? And then lastly, is it, if someone dies, how does it pass? How does title pass? Probate wise, how does that work? Because even though you might have a state court saying, hey, this is passed, its person died, their will says it goes to Gary. How does Gary go and get it? What does that mean? A lot of these things at a state law, property wise, that since there's no governing body to regulate it, how do you get into it? How do you account for it? And then you even list it on the estate tax return. If you can't get the money, is it a loss? If you lose the key, you're not going to be taxed something you can't get to. So all these things we will talk about. We'll start with basis. And this is, since it's treated as property, this is no surprise to you all. The easiest one is cost. You go on to an exchange and you buy it for US dollars and you know exactly what it is. You put it in your wallet. But since it's property, you have to track the holding period. So in a best case, every time you would acquire these things, you would open a new wallet. And the date you bought it, you could do the holding period. So then when it's disposed of, it's easy. It's just a capital asset. You got the, if it's a year and a day or more, long term, easy. But no one wants to do that.
The criminals do that.
The criminals do that.
The criminals do that. My understanding is the criminals do with the wallet, so they don't even have to have a transaction.
That's right.
They just give the number to whoever they're giving it to. Yeah, it's pretty complicated actually.
But from the perspective of taxation, though, if you're just a above board taxpayer, and you have one wallet and you keep acquiring these things and you dispose of them, what do you do?
Do they have a first in, first out?
They have a rule now, and we will discuss that. But there was actually a debate for a while how to do it, because even though it's really like it's fungible, it's not. They say it's like anything else.
It's totally fungible.
Yeah, but they claim it's not. So anyway, they did compromise. If you can't track it, they did give an accounting method, and I will leave you in suspense on that until we get into it. And then also, they did allow, there's a question is, can you pick? They're all in one wallet. How do you verify that's the actual one you bought on that date? And so we have guidance now on how to actually do that, that's what the 2019 FAQ told us. So that's one. Two is to transfer. Obviously, if you gift anything, it's a transfer basis that hasn't changed. However, if you can't substantiate basis, guess what it's going to be? Zero.
Yep. Yeah.
So make sure that if your clients acquire it by gift, they're able to substantiate the basis. If it's on an exchange, that should not be hard to do. If it's a major type of, if it's Bitcoin or Ripple, you can go on the market and see how it was. But if it's one that's obscure, then you might have a harder time. Inheritance, the rules are the same. You'll get a step up as a date of death, but again, you have to substantiate that. Now, the other would be exchange. So if I need legal work and I go to Gary and I want to pay him in Bitcoin,
he'll say no. But just
first off, he'll say no. Hypothetically. So then I'm exchanging property for services.
Well, we know how that's going to go.
Right. So then I would already have for the basis I acquired that asset some way, either by cost or inheritance, whatever. Okay.
Well, you exchanged.
What I'm saying, but I initially got it to start with.
Oh, the original Bitcoin.
Right.
Yeah.
So if me being the taxpayer that's paying with it, I have a basis on that.
Sure.
But when I pay him with that, the value for him is the fair market value of the services he provides me. So that's the basis he'll take in that Bitcoin.
So I'll take the current value of the Bitcoin, right?
Well, no.
Isn't that what I take?
It's supposed to be, but the way that the rule works is whatever your fair market value is, which you would only charge what it's worth at the time we make the exchange. Now we'll get into the ethical issues of you accept it, then it goes up in value immediately. Do you have to give it back if it goes down? What the issue is?
No, so they weren't clear on, well, as of the day you make the payment, you sell it at the current value, and I take it at that value, and that's my basis now.
Right. Well, yeah, you would think that, but it's actually the way it's defined. It's the fair market value of services. The idea being that they wouldn't exchange it for more than it's worth, unless it would be a part sale, part gift, something like that, or a part making a partial gift. If I paid you a Bitcoin that was worth $60,000, and your service is only worth $20,000.
Well, what if it's arm's length? Why would you do that?
It's supposed to be the fair market value of the services.
So the IRS is complicating a very simple issue.
Of course,
yeah, that's
what they do. But anyway, that's how they do it, because it has to do with property. Yeah. And it's supposed to be based on the fair market value. Now, I'm sure if the IRS got whipsawed, they would argue otherwise, but that is the general rule as in the FAQ that they released. But it's interesting. It's not what we would think it would be. It should just be the fair market value of what it's worth.
I wonder what they're getting at, because that doesn't make much sense.
I don't know, but that's how it's governed.
Okay.
And then lastly, the last way that you would get the basis if you were a minor and you got it from working, it would be the fair market value of the asset when they received it. Mm-hmm. So it's very strange. And then if you exchange things, so this is the one that I always find fascinating. If I have Bitcoin and Gary has Ripple and we exchange it, I guess the idea would be, since it's arm's length, to be the same value.
We can make a new coin called
BitRipple. Yeah, BitRipple. That's right. Anyway, so
Brian's the expert here, by the way.
It seems straightforward, but when you exchange things for like services, generally you would not overpay for what it's worth, but there's potential for arbitrage there. So just be aware of that, at least under current law. And then we already discussed the determination of the holding period. You just need to be able to substantiate it. That's the main thing. And now what's interesting is we have had clients that have attempted to get a step up when someone's ill. Just be aware of the step up or step down rule within a year of death. If you give something, it's not going to get a step up. Just be aware of that. Okay. So what happens when you actually dispose of it tax-wise? And then what are some of the examples of, okay, this transaction or this action occurred, is it taxable? And I'm going to go through some examples, but you already know the rule, which is property, long or short-term gain or loss. That's it. And at every transaction, it's a taxable event. So if you buy it for US, so if I have it and Gary buys it from me in US dollars, for me who owned it, it's a taxable event. I have a basis of how I acquired it. We have an amount realized, and then we have a gain.
You have a time frame,
right? And then you've got the holding period, and so you can report it. And there's actually a box now if you own it and if you exchange it, and then where you would report it, and we'll get into that in the compliance area. If you use it for goods or services, same thing. It's kind of like a barter. It's taxable event. If you exchange it for other, types, so from Bitcoin to Ripple or Ethereum or a Dogecoin for a while there, it was big. Every time we had a client made a lot of money on that. It's a taxable event. If you gift something, it's not taxable. That's, makes sense. If you make a transfer from your wallet to another wallet that you own, it's also not taxable. That's not a true disposition. You're just moving where it's located. You haven't disposed of it. And then lastly, if you buy it with US dollars, when you actually buy it itself, that's not taxable when you buy it. It would only be when you dispose of it later.
Gifting cryptocurrency could create the gift tax.
It could and does.
Yeah, so we want to make that clear.
That's right. It's on the income side. The transferred taxes would apply to any gift.
Mm-hmm. Just doesn't trigger a gain.
Right. And then what happens if it goes to a foreign trust?
Yeah.
That'd be interesting to see.
Yeah.
We'll find out later.
Okay. Maybe.
And then with some more examples, obviously if it's sold for a fiat, not all that means is it's a governmental, any governmental type of currency.
When you recover your Bitcoin, it's exchanged back into dollars into your account.
Right.
So you automatically trigger that exchange.
Right. And then, if you barter, it's going to be taxable. And then if you exchange it, it is. Now, we know for sure now, I think I already discussed, but, we do not get like-kind exchange. There were some taxpayers that took that position back in 2014, 15, 16, but now we know for sure the code is clear. It does not apply to anything but investment real estate. So, compliance. You have clients that own these types of assets. They've acquired them in a year, they've disposed of them or both. What do they have to worry about? And the number one thing we can tell you is that you'd be surprised at the amount of information that the government knows about these things now. They've come a long way. And so one of the things that is newer in the last 4 or 5 years is this 1099-K reporting to the IRS. There were some exchanges, Coinbase being the main case, saying that, it's offshore, the U.S. does not apply. And so the IRS, they issued a John Doe summons to them saying that we know you have U.S. resident taxpayers with accounts there. We want their information, their name, address, TIN numbers. And of course, they fought it because the whole reason why they were offshore was to get the business. And a federal court said, you have to give that information. And so if they have more than 200 transactions, the business itself, the exchange does, and more than $20,000 in aggregate value at any time during the year, they have to report the individual to the IRS with their name, address, ID, and their account number.
Interesting. So it depends on which country it's in, because some countries have a tax information exchange agreement, some countries have a treaty, some countries don't have anything. So I guess it's going to depend where that exchange is.
Right. So but they're doing a lot more. So these individuals that will tell you, hey, you don't need to worry about that. The government's never going to know about it. If they have an exchange and there's an exchange agreement with the U.S., they're going to be getting that 1099. And
if you ever bring it back into your account,
right?
If you bring it back into your account, you'd be in the U.S., you constant reporting. Or if you're in Cayman or something where there's a tax information exchange, there's a flow. It's not even reporting your transaction. There's just a constant flow of information. It's totally available to the IRS.
Right. And they do get it. And then, a lot of times now when there is if they believe that your client has one, they will now send them a letter saying that, hey, if you have this type of asset, make sure you're doing X, Y, Z. And a lot of times it's just informational. It might be taxable. You need to think of it sort of like it's analogous to a foreign account. They just want the information on these things, your wallets. And then so when it's sold, they're getting their tax money. That's really what it's about. Now, if you're an investor, trader, or dealers, there are different rules. These are just for basic tax payers. If you're, any of those things, on a large scale, there's more compliance and you need to be aware of, but that's beyond the scope of this CE. And then we also wanted to just discuss with you guys, this case, SEC versus Mr. Shavers. Big surprise. Mr. Shavers was doing things with Bitcoin, selling them in some type of business arrangement, kind of like stock in a way. And the SEC issued it, they wanted an injunction to stop him from doing it. He argued, hey, these aren't investments for money. This is just this unique type of asset. I'm not trying to do anything. And
it's just currency.
It's just a currency, right? And the court said, no, they're investment contracts. And so the SEC can regulate and cause all those things to do. So if you're trying to output your own, if you want to start your own ICO or something, you need to go through all the rules.
That's why they did it.
Right.
If it was just really like a currency, if a Bitcoin was the only one, he might have gotten through with that argument. But
right.
When every teenager starting their own, coin, that's probably the SEC is not going to really.
It's really not that hard to do it, believe it or not. But it's becoming. It's very ubiquitous now. Oh, I want to start this. I think it's a get rich quick deal. I can start this, make all this money, and then I'm out.
Oh yeah. Well,
so
it may be, but you won't be out.
You won't be out.
You may be in.
You'll be in the pen. But so anyway, we don't advise that. But there's things that would like to do it. So, but it really, when it comes down to it, and now we have more guidance on it. But believe it or not, there was a case in Florida in 1946, Howie in the Hills, where a gentleman had an orange grove. He sold bits of the enterprise, or he tried to.
Well, they sell little strips.
Little strips,
land.
right?
Yeah, little strips of land.
Little strips of land.
Yeah, like little tiles.
And the government didn't like that. So the SEC came in and said, hey, we have all these rules from 1934 you need to do if you're going to do this type of transaction. And the guy's like, well, I'm not really selling, I'm not doing an initial stock offering. I'm not doing all that. Well, if there's an investment of money, common enterprise, and profits are controlled exclusively through the work of others, these rules apply. These security rules apply.
This publicly selling things can be very, very exposing.
Right. And so, you just need to be aware of that. And now basically they say that if you have a client that wants to do one of these things, the rules from the SEC apply. So just be aware. Interesting enough, there is a little bit of guidance for traders as relates to crypto. It's mark to market. So, then I have the rule there, the reg, if you're interested in that. It's, obviously that's a very unique, specialized thing. Now, accounting method. Now, Gary, if you had to guess the accounting method, what would you say?
I think it would be one of these first in, first out cash basis.
Yeah.
That's as good. That's my accounting background. We're tax lawyers.
Right.
But the accounting method, that's so go ahead.
Oh, sure.
There
actually is an answer,
Okay.
So on the FAQ from 2019, in question 40, it tells us that generally you should track everyone as a unique thing. That's what they would like. But they realize that doesn't happen. So if you can't identify, it's all in one wallet, and you can't identify what it is, and something's been sold, you need to apply a FIFO method. First in.
Oh, so I got it.
First
I
out.
kind of got
You are
it. Well,
correct.
they defaulted. They want every single transaction.
Right.
I wonder how they do if they do a block of them. You're going to lose track of the timing, aren't you? Okay. Well,
Yeah, I mean, but yes, it's a FIFO, but then you get into timing.
right.
So it's short term. That's what they like.
Oh, sure.
They don't want long term. So that's one of the reasons why they did that. So it's better if you can track.
Yeah, right.
But if you can't, I mean, it is. So at least we're not, taking some position that we're not sure of. We know now this is what you can rely on this from the IRS. So that was interesting. Now they put out a revenue ruling, also in 2019. It's very specialized as relates to a fork. I don't want to get into it too much because it's very complicated in what it is, but basically, if a cryptocurrency decides to change their protocol and they split the type, or you might have something to where an example of this would be Bitcoin and Bitcoin Cash. There was a circumstance where a big exchange was hacked. It was probably 8 or 9 years ago. Mount Gox was the name of it. Well, a lot of these criminals made off with a lot of Bitcoin. And so they decided to start a new chain where it broke, and they called it Bitcoin Cash. Well, if you had Bitcoin, you also got this new thing, Bitcoin Cash. So then there was a question of, well, does it have any value? Is that taxable? Is there any basis? And the difference between a hard and soft fork, did you receive anything or not? I mean, so the revenue ruling goes through the examples and goes through when it's taxable or when it's not. And it boils down to basis. I mean, that's really what it boils down to. And if you acquire basis, you have income. That's the logic of what they're trying to do. And if you don't get anything back, there's no basis. So, we recommend that you read that so you're aware. It's very rare that you're going to have a client that has that, but if they do, you've got guidance now. Just be aware too that there are really a lot of banks now too, as this is becoming more mainstream. A lot more institutions in IRAs even allow you to invest in these types of assets, but you'll have know your customer, know your business, and know your transaction forms. So just make sure that your clients stay with compliance with that. If you don't, it can get nasty. And then if you have a client that has an exchange, they can enforce serious penalties on you for negligence. Oh, I don't know what's going on. I don't know who these folks are. The BitNext case, they put huge fines on an exchange. Interesting case if you had a chance to read it. Okay, we talked about Coinbase, the John Doe summons. You just need to be aware of that. The IRS, starting in 19, they started a compliancy campaign, kind of like the offshore accounts deal, where if you've had these things, you can then acknowledge in the IRS
like a safe harbor.
Right, a safe harbor. So that, I think that has like run out now, but there is a lot of good information. If you go in and you read on that, you can see what was going on and why. And they really have made it a point now to enforce these types of assets. So be aware, you're going to see, I think, a lot more cases in the next 2-3 years because of this compliance campaign, that these things are now going to come to a head. Now, if you do have a client that disposes of one and it's a taxable event, you report it on the form 89-49 attached to their 1040. So that's where you will report the assets, the dispositions. Now, if they have a foreign exchange, if they have a foreign exchange where the wallet is, we know now that the FBARs apply because it's a foreign account, considered a foreign account offshore, and that's the US v. Hong case. Just need to be aware of that. Make sure your clients are staying in compliance. The same thing with FATCA. It's a foreign account and they exceed the threshold of value. Make sure that they file that. we have a website here for the Financial Crimes Enforcement Network. This is a great resource for you to read up on. If you have a client that has substantial assets offshore, they need to make sure that they're following what they need to be doing. Now, most of the exchanges and they have trustees offshore. They should already know this, but at the end of the day, the taxpayer is responsible. So make sure
it's a matching system,
right.
And you're going to fall into very onerous rules that we deal with foreign trusts and foreign LLCs all the time. But it looks like if you're going to have a client use a foreign exchange on one of these cryptocurrencies, you're going to have to file all those forms.
Right. And then penalties are outrageous. And it's information.
Yeah.
I mean, it's just information. Now, I always love the cases because they're interesting, and that's where practically all these rules come together. A great case is USV Viella. I guess that's how you say that. He was, we assume based on the case that he probably was doing some nefarious things, maybe some organized crime. And he was charged with money laundering with Bitcoin. And he argued the IRS says it's property. I should be charged with this. Well, the federal court said, no, it's money as relates to criminal law. And so he went to the pen for a long time. So interesting that. Now, on the state side, in our state, in Florida, the Espinoza case, he argued the same thing, and the state of Florida court said, you're right. You can't be charged with money laundering. So the very next year, the legislature changed the law. And then the most interesting case is the Ulbricht case, Mr. Silk Road. Back in 2011, he ran the exchange for this Silk Road, which was a dark web platform where you could exchange Bitcoin, other types of currency for all types of bad things, weapons, ransom, drugs, murder, extortion, all those things. So he argued the same thing, but he's obviously now in jail. I find that interesting, but it's definitely considered money, as for at least for FinCEN reasons.
Yeah, the criminal side is very onerous.
Yeah. And they equate it to money, basically, on the criminal side. Okay. We have.
Really? Wow. Now that you're awake, I'm going to put you to sleep. No, just kidding. So we're going to have asset protection, which is the flip side of the cryptocurrency. So the cryptocurrency is interesting in its own way because it operates on an anonymous blockchain. Interestingly, it's almost ironic because we went from this blockchain issue to exchanges. Like one of the big attractions to the cryptocurrency is that it's anonymous. It's a number on a chain, and then when you go to the exchange, it becomes not anonymous. So, with that in mind, we go to how do we hold the cryptocurrency, right? What's a safe format? We're going to disclose. We're going to tell the IRS everything. If we're offshore, what do we do? If we're not a citizen or a resident, what do we do? If we're a non-citizen and we're coming into the States, we're considering coming into the States full time. What do we do? From a protective standpoint, we can go foreign or domestic. For U.S. people, we often use domestic asset protection trusts for single people. So, for instance, on a protective basis, if we very common, you form a family LLC and husband and wife hold by the entireties, the kids have trusts. So you have a strong multi-member LLC. And then if someone sues a spouse, you can't even lien the LLC because it's held by the entireties. That's a very common format in Florida. But what if we don't have a husband and wife? So what happens for single people is that the individual is sued, has the LLC interest, but the individual can be liened. So you can't get any money out. You have to pay the creditor if the equity is liened. So the domestic is convenient in the sense that we can take the single individual's equity and put it into the domestic asset protection trust. We like Nevada, South Dakota is also good. And under the laws of that jurisdiction, if the individual sued, you can't even lien the equity. Some of the cases have been good. Some of the cases have not been good. Usually it's kind of a bad actor where they try to break through it. But the reason that when we go through, whether we're going domestic or international, if we're doing something that's not too exotic and it's a single person, we oftentimes go domestic, but you can see the factors on the slide. Well, it's still subject to the Full Faith and Credit Act. We've defended several of these domestic asset protection trusts, all successfully. But you have to keep in mind, if someone gets a judgment against the individual in Florida, the Full Faith and Credit Clause of the U.S. Constitution says that judgment can now be registered in any state, and you can collect on that judgment in any state. So if the assets are in Nevada and the trust's in Nevada, typically you take that judgment and go to Nevada, and the judge would say, well, no, the judgment's against an individual. This is a trust. You can't collect. But if the asset's in Florida, the judge is going to be very tempted to say, we don't do domestic asset protection trusts here, or, and we're just going to ignore it and take the asset. Let's say the judgment's in Florida and the money's in Georgia doesn't have an asset protection trust, we're going to ignore it. You can have the money. So you got to be very careful with the way it's applied. It's not as ironclad as a foreign trust where no court in the U.S. would have jurisdiction over the asset. It's very powerful when we can keep an asset abroad and use a foreign trust. We've got a case that these two cases on the bottom here, Huber and Mortensen. Huber kind of symbolizes the whole idea of two things. One is when we do a domestic asset protection trust, we want to make sure that there's a connection between the client, the grantor who funds the trust, and the jurisdiction for the trust. Huber was a developer. He funded an Alaska trust, and he really had no other connection to Alaska and didn't create one. So the co-trustee was in Washington State. The money was in Washington State. Everybody lived in Washington State. All the assets were in Washington State. And so
the trustee was there too, right?
The co, yeah. And so we didn't get a clean look at it because he filed bankruptcy. So when you file bankruptcy, what happens is, you can't do that, is the court has much more power over the assets in the bankruptcy estate because the whole positioning is different. When you file bankruptcy, you are discharged of your debts, and kind of in exchange, you submit to the court. The court is supposed to uphold local protections, but in many cases, like an exotic issue, like a domestic asset protection trust, they'll use the idea of public policy to reach the asset. And if you don't have that connection to the jurisdiction, that usually raises this public policy argument, and like where you lose the assets. Mortensen was another bankruptcy case where you had a mountain man essentially plan to have a divorce. So the mountain man has assets in Alaska, the trust's in Alaska, he's in Alaska, everyone's like, he's got the connection, right? And they have a 4-year statute of limitation on fraudulent transfer. And so what happened was the 4-year statute ran. So he funded the trust, and then the reality was a claim to get the assets in the trust, that he was doing it to avoid the wife or the creditor, was essentially over. The 4 years had passed. There was no way to get the assets, but he filed bankruptcy.
Big no.
Yeah. And he extended the statute of limitation. Bankruptcy extends that statute to 10 years, and he lost the asset.
He was going to show her. He did.
Too much. On the collection, we talked about the connection to the jurisdiction. There are a couple of interesting cases on the LLC side. When we have someone doing fraudulent transfers, we had this Sabrina Barber doing essentially she had encumbered herself with a huge amount of debt in the real estate boom. It went bust. She was trying to hide assets, which is really a fraudulent transfer claim. In other words, if you're a creditor of her and she moves assets around, you can come in and say, well, that's nice, but she did that to avoid my claim. She knew she had the debt to me. I can go get those assets. I can go to those people or entities that got the assets and pull them back and collect on them, foreclose them essentially. So she moved things into a Delaware bank account. She moved things into a Nevis LLC. The Nevis LLC is a very good LLC, by the way. We had a hand in drafting that LLC, but it was a fraudulent transfer, in my opinion. So Wells Fargo goes to court and says, you know, what's going on here? She's moving stuff away. We really need to collect those assets. All the assets remained in Florida. Wells was in Florida. They sued in Florida. The court was in Florida. And interestingly, the court didn't say, well, that was a fraudulent transfer governed by Florida law. We're going to go ahead and let Wells Fargo collect on those assets because they're improperly transferred. She didn't move the assets off to Nevis, or she didn't move even offshore within the LLC. It was still would have been a fraudulent transfer, but harder to collect. But the court didn't go in that direction. The court said, and my partner actually said, well, they're probably going to call it a Florida LLC. It was not a Florida LLC, but they did. They said, well, we're just going to call it a Florida LLC. And she's a single member, and single members aren't really protected. So we're going to ignore it and take all the assets. Whereas I thought they really would have followed the reasoning in the law with respect to fraudulent transfer, letting them take the asset because it was improperly funded, but they just kind of ignored the whole thing and threw it away, and Wells Fargo got the assets in Florida. You got to be very careful with this fraudulent transfer stuff. Even if the court doesn't have any idea what they're doing, they don't like this idea of being able to move things around so that you can't get it, so that the creditor can't reach it. It's eventually they'll get to the right argument and you will not keep those assets. There's several arguments on the other side. There's an Alabama case that's very creditor friendly, where you have to go to the Arroyos, it's called. We have to go to the jurisdiction of the LLC to collect. And then there are these two cases with respect to the certificate for the LLC. Sargent, this case, says you have to go to where the certificate to the LLC is. So you can take your judgment and go, in this case, to United Arab Emirates and Dominican Republic and record it and collect there. Well, some jurisdictions really allow for that. Other jurisdictions, very, very difficult to do that, like Nevis. The Shim case, which is in a competing jurisdiction in Florida, says, no, you don't have to do that. You don't have to do that. They cite a case from like 1847 that says once the debtor is in the court can hold that debtor in contempt until that debtor takes the assets, in this case the certificates, and bring them back to Florida. I think it was pretty established law. It's very lightly litigated. It's very lightly litigated. They really couldn't find cases because we talked to the litigation team here on it. It's pretty clear. So as far as our litigation team goes, it's probably going in the Shim direction. You can't just keep the certificates offshore to prevent the court from collecting.
The Florida Supreme Court has affirmed
Shim recently.
So yes. Yeah, very, very recent. Also, I think it's important to distinguish between getting the judgment and collection. They're two different things. You sue someone, you get a judgment, they owe me X amount of dollars and damages, and then you have to go collect it.
Mm-hmm. And then if the court sits through the trial and there's funny business going on, the court's typically going to allow whatever. They'll hear any argument. In this case, you're not going to be able to shift, certificates offshore to prevent the plaintiff from collecting. This is a little bit older diagram, but goes through the salient factors when you pick a jurisdiction for an offshore trust. there's all kinds of protections that may be involved in you know, a creditor suing, they have to post a bond even to file suit, the standard of proof. This is the collection side where these are these are debtor friendly, creditor adverse jurisdictions, which create a lot of barriers to collecting. But honestly, the key is, if you want to fund a foreign trust or foreign LLC, do it while the skies are clear, there's no issues going on. Do it in a protective jurisdiction and keep the assets funding the trust offshore. They don't necessarily have to be in the same jurisdiction as the trust. If you fund a Cook Islands trust, it's halfway around the world, you know, and you have the assets, you know, in wherever, Belize or wherever your favorite financial jurisdiction is, like Switzerland, that's okay too. You see how we're doing on time? Okay, we have 40 minutes. When we select a trustee, essentially what we're doing is we're deciding that if we use a foreign entity on a professional that has no connection to the United States, because the last thing we want to do if we're using a foreign trust and we're using it for future asset protection is to have someone we can collect from in the US. That's what Sabrina Barber did wrong, really. I mean, she was way late to the game and did fraudulent transfers and all that. But theoretically speaking, you want to have a corporate trustee with no offices in the United States. We use a few of them with billions of dollars that they're holding as trustee. And of course, people ask, well, why would I create a foreign trust with a foreign trustee? Well, that's what creates the protections. We don't allow the trustee to just remove assets whenever they want. We appoint a protector. So a related party can be protector. There can't be any checks cut without the protector's consent, even signing the check. We have a very trusted financial advisor who's at the bank or the institution that has the assets, this type of thing. We've never had any risk or problems with a foreign trust. It's just that you have to put the applicable protections in place. On the tax side, as background, you know, we always look at the distinctions between income tax and estate tax. For US persons, that's this first slide. Income tax is worldwide. We've got CPAs in our audience. They're, you know, aware of this. Estate tax is also worldwide. The difference, you know, between estate and income, though, allows for a lot of planning. Essentially every client that comes in knows the income tax rules. It's are you here more than half the year, or do you satisfy the substantial presence test, which is an averaging of the last 3 years? It's a weighted average. And there's a cocktail party rule. Everyone in Brazil, I think, knows the cocktail party rule, which is if you're not here for more than 120 days a year, you're not going to become an income tax resident. Now, many people come and they become an income tax resident, but they're not here permanently. So that's a difference. So although they may be taxed worldwide on their income, and they're okay with that, at least for a period of time, they're not estate tax residents. So they're not taxed worldwide on their gifts and estates. It's an interesting planning format based on the specific circumstances of the client. If we keep the estate out, the idea with the estate being, if I'm here and I want to stay forever, that's an estate tax resident. That's an estate and gift tax resident.
Based on domicile.
It's based, that's called domicile, right? If I'm here, but I'm not going to stay, and it's obvious I'm not going to stay, you're not an estate tax resident. So what does that allow for? Well, if I'm an estate tax resident, I'm taxed worldwide on my gifts and when I die. If I'm not, there's a whole menagerie of different rules, but I'm not taxed on the gift of foreign assets because there's no situs to the US. I'm not an estate tax resident. So we can allow for the decrease of those assets if one day there's a change of heart and they become a resident, those assets are out of the estate. There's also an allowance for the gift of intangible assets at no tax, which interestingly enough, if the non-resident alien, we say non-resident, non-citizen, dies with those assets citus in the US, there is an estate tax. So we always want to utilize that. We often, what we do is we just create a foreign entity, and that foreign entity holds US assets. When the foreign individual dies, there is no estate tax, because what the code allows for is the blocking of the estate tax, because that entity doesn't die.
And the exemption amount for a non-resident, non-citizen with U.S. situs property is only $60,000.
Essentially, there's no exemption, so we always want to use that offshore entity. Pretty much always. If someone's coming into the States, by the way, or it's likely, and maybe they're not currently a U.S. Domiciliary, you've got to keep that in mind, because what happens is you go from that $60,000 exemption to what's currently, $26 million. So sometimes we want to, believe it or not, we want to become a domiciliary for that middle market. And that way we can use, in other words, if they're foreign, but they have a lot of US ad, they've been investing almost exclusively in the US, and it's under $20 million, and we get stuck with some kind of FERPTA issue, or we can't transfer assets offshore, we will bring them in, and they'll get the big exemption, and there's no estate tax. This is the non-resident, non-citizen. These are the general rules. On the income tax side, there's a withholding on passive income. It's a flat tax. A lot of people aren't aware of that. There may be an applicable treaty which eliminates or reduces income tax. And then you have these foreign trusts that are essentially treated as foreign individuals.
Just make sure that the non-resident, non-citizen does not die with stock.
Right, that's the intangible issue.
Right.
So you can give the stock away while you're alive.
Sell it.
Exactly. Sell it or sell it on the income tax side and no gain.
But don't die with it.
I can't tell you how many people are not aware in the US of this idea of buying and selling stock at no gain to the non-resident, non-citizen. Totally unaware. The foreigners are totally aware. But it's good as CPAs to be aware that, you'll see these sales back and forth by non-citizen, non-residents. There's no tax.
Just make sure too, if they come into the United States, you have clients and they're going to buy real estate, make sure it's not in their individual name. It's in a foreign.
Right.
entity.
Now, when they sell the real estate, there is a FERPTA anyway. But if they die with it, there's no estate. Now, one thing on that, it doesn't come up much, but I did do a very large transaction on it. If you sell the foreign entity that holds the real estate, there's no tax. So occasionally on very large transactions, you can negotiate a sale of the purchase. This was a BVI entity of the BVI, interestingly, and there's no tax to the seller. And it could be, this was a massive property. And here's what we talked about on gifts, with no gifts on gifts of intangibles.
Treaties too need to be aware sometimes.
Yeah, treaties can help. Treaties can help. They don't come up in South America, but European and some of the Far East, we've got some pretty good treaties. And then you always want to determine, when you're going into the trust world and you've got clients with foreign connections, and you don't want a foreign trust, you don't want this massive reporting, you're not intentionally creating a foreign trust, you're not really doing asset protection work, you're not doing pre-immigration planning, you're not doing expatriation, whatever, and you appoint a foreigner as a trustee, you create a foreign trust, which is a mess. Basically, if the law governing the trust is foreign, you've got this first court test, the authority to bind trust operations. Or a U.S., a non-U.S. person manages it, you got a foreign trust. If you got a foreign trustee, and there's so many times people come up, well, I appointed my uncle in Holland, and it's like, oh my God, now you didn't report for 5 years. You got all the FATCA and FERPTA, FARBAR issues. It's a complete mess.
Mark to market too, depending on what it
Yeah,
is.
you can actually have a mark-to-market expatriation of assets issue depending on whether or not you have U.S. beneficiaries of that trust. Oh, and here it is. This slide is an entire presentation. It's hard to digest all of this, so quickly. We've only got a half hour left, so I want to make sure we cover some of the big points. But the idea is, Brian alluded to it. If we have a U.S. grantor and we have U.S. beneficiaries and we want to create a foreign trust, the general rule 679 says it's grantor, which avoids the general rule in 684, which is if I move assets into a foreign trust, it's a deemed sale of those assets. So let's be careful. If we have a U.S. grantor, but we don't have U.S. Beneficiaries, we could create a deemed sale of assets, right? And so as long as we understand that, we can deal with it. We sometimes do cash. We sometimes do non-built-in gain assets. Does it come up that much? No, because we almost always have a U.S. beneficiary on it for a U.S. grantor. So there's a second stage to it, which is almost always missed. So basically, if we have a grantor trust, which is deemed under 679, so there's no deemed sale, the sale treatment does occur at death. So what does that mean? So upon the death of the grantor, there's a deemed sale of those assets. So we have to be careful. If the assets have gone way up in value, we get double hit. So if at that point there's a mark-to-market sale, and those assets are part of the estate, no problem. We got to step up in basis. There's no gain, mark-to-market, on the mark-to-market. If the assets were given this is the income tax side, on the estate tax, gift tax side, and they're no longer in the estate, well, we got a problem. Because there's no step up in basis. They've gone up in value. There's a mark-to-market tax. Got to be very, very careful with that. You agree with that?
No, I totally agree.
I mean, it takes us a while. People don't really like us spending so much time.
Yeah.
You know how lawyers are. But this really gets involved.
Right. A lot of times when you have a successor trustee who is not in the United States, this is when this potentially could occur. If you don't have an asset protection trust to start with, you just have a domestic trust with stuff in it. If you name a foreign trustee,
that's true. The conversion.
Right.
And you may have done a completed gift of those assets.
Right.
That's a good point. That does come up. So at that point, either the client runs out of the office really quickly,
and they're angry at us for telling us.
Well, that's part of the running, and then or we plan it out. We usually can plan it out pretty well. On the pre-immigration side, it's kind of the opposite. You have a non-resident, non-citizen, right? And while they're offshore, this is the offshore one. I want to make sure I got the slide right. Yeah. Mm-hmm. And while they're offshore, they kind of they're not resident for U.S. estate and gift tax purposes. So there's no tax on these foreign assets. So we start giving these assets away. And a lot of times we use a foreign trust because the client doesn't want to give directly to the 5-year-old. And so we use a foreign trust. We get the assets out of the estate, which is a great move. If someone's got 100 million, we get it down to the exemption. They come in, they use up their assets somewhat. They consume, they get under the exemption. They come in, but we got to be careful. There's a 5-year look back. So when they come in, they're deemed to have made that transfer on the date they come in, right? So although the assets are out for estate and gift tax purposes, now we stepped into the income tax mark-to-market deemed sale. So we've got 5 years to deal with it. So within the 5 years, what we do is, because if the grantor dies, we're going to have this mark-to-market issue on assets that are not going to get a new basis. It's going to be a gain on those assets. We domesticate the trust. You won't hear a lot of lawyers explaining this to you. I don't know why. We have people come in all the time who spoken, especially with big firms where it's this kind of secretive process. We domesticate the trust and it eliminates that mark-to-market tax. The IRS wants the assets here. Let's make them happy. They're already out of the estate. So there's no estate tax.
It's income.
It's just income tax. Yeah. They want to see the income. Okay. So we bring it into Nevada or South Dakota. Everybody's happy. There's no estate
And then
tax.
all the compliance we have to do.
Oh, right. That's
all,
true too.
All goes away.
All goes away, right? These are compliance issues. The 3520, actually, Brian does a lot of this work. This is the matching form where you have a foreign trust, the trustee has to sign, the beneficiaries have to sign, everyone's involved. So you have anything to add?
No, I just,
like
I said, I mean, it's informational. This is how they match, as Gary said. Basically, the deemed owner, U.S. deemed owner of a foreign trust, and any U.S. beneficiaries have to complete this form each year. Goes with their 1040. You attach it, and along with that, we'll talk about another form that's filled out by the foreign trustee each year. There'll be a statement that will be attached. You'll have a foreign grantor trust owner statement, and you also have a beneficiary statement. You'll attach that, kind of like a K1.
So who would coordinate that in general?
Well, generally the foreign trustee would, because they would issue these documents on March the 15th. They're due out. Mm-hmm. So you would get them a month in advance. So you would have them for your return. If they don't, or they don't know what you're talking about, you need to get a new foreign trustee, because the U.S. owner is responsible, isn't they? That's the issue, right? But a big corporate trustee that's a foreign trustee, this is like run of the mill stuff. They do it
this is the part of their job.
Yeah, it's part of the job. So that's what you're paying for.
Also, we only use one specific Swiss bank, and they're also very dialed in with it.
Right.
If something's missing, you want that backup. You want your CPA to understand. You want your tax lawyer to understand. You want your foreign trustee to understand, and you want the person managing the money to totally understand. Usually, if those four are involved, you're going to be in pretty good shape.
Right.
Remember that the compliance doesn't end here. You've still got the FATCA, you've still got the FBAR, and that may apply on a number of different assets, especially on some of these grantor trusts, because it's really going to be you look through. So if you've got a bank account, if you've got a foreign asset, it's quite a bit of filing. A lot of clients ask us, at what level of funding is it worth it? Is it worth it? It doesn't really work like that. Some people do these for asset protection purposes. We have some major physician groups. While nothing's going on, this is a very nice asset protection vehicle, the foreign trust. Another area that's been very significant with respect to asset protection trust is, we do a lot of M&A transactions. And as part of the sale, we represent the seller a lot of times, not the fund buying the seller. There's an indemnity, and the indemnity could be the full sales price, could be more even, where someone's, or a group is involved, and there's 40 or 50 million dollars of sales price, which they have to give back under certain circumstances, many of which arise from the buyer mismanaging the business. So we say, well, let's take a part of the consideration. You got 50 million. Let's take 5 million. Let's take 10 million, and let's go ahead and fund a foreign trust with a foreign trustee and the assets held in a foreign jurisdiction. We go through all of this compliance, and we know it's a pain, but we've got a real exposure. So there's no fixed amount of money that we would say, okay, this is the amount you would really, when you really start to look at, okay, should I fund a foreign trust? But there probably is some kind of minimum where the compliance, the cost of forming the trust, the hassle, comes into play. It's just something to think about. It is a different endeavor for clients that are very sophisticated, that are doing transactions all over the place. It's usually really not a big deal to them. For a client that just is it brand new to the financial world? It's a lot to digest. This is the owner disclosure.
Yeah. So the foreign trustee on an annual basis will prepare a form 3520-A, and this just gives its informational return for the IRS, and also prepares the foreign grantor trust owner statement and the foreign grantor beneficiary statement for the U.S. individuals that are attached to the trust, be it as the deemed owner or as a Benny. Note that this happens each year, even if there's no income tax due. You still have to fill out this form, and it's required.
That's a good point.
And the individuals, the deemed owner and the U.S. Bennies, have to attach the statement, even if no income is distributed in a given year.
And that's the trend. That's the trend with, you saw that with Bitcoin, you see that with the foreign assets. The idea is you disclose, they enter, they check the box, and now the IRS knows to track. Eventually, at some point, they're going to have software, because they've been funded so heavily this year. They're going to track this asset. They're going to track it. And if for some reason that check mark doesn't come up on a return, you'll get a letter. You'll get a letter. It'll come from a computer, but you'll get a letter.
Absolutely. And then, as we said, the U.S. Benny of a foreign trust, even if no income or distributions received in a given year, they are still required to file a 3520 each year and attach their statement from the 3520-A. So on a compliance side, it's very important, even if they're not getting it, if they accumulate the income in the foreign trust, the U.S. Benny has to file this form each year.
Yeah.
And of course, we have the FATCA.
These are some details.
Yeah, it's a compliance side. This is broad strokes, but just be aware. If you have a foreign account, foreign trust, foreign wallet in exchange, all these thresholds, if your client exceeds them, Form 8938 has to be filed for that individual, disclosing those assets. And then, of course, the same with the FBARs, more than $10,000. I mean, it's almost any account.
It's pretty onerous. I mean, we've had a number of people call, and if the numbers aren't significant, and it's been a few years. I remember one woman was basically moved with her husband and was teaching, and her, she had like $60,000 or something, and several years had passed, and she pretty much had to give up the account.
Yeah,
they caught her in the thing. The safe harbor did not allow her to. It did not avoid some of the penalties. This was when they still had it. Now there's no safe harbor program anymore. OVDP. Yeah, it wasn't that. There's no program anymore because people stopped doing it because it really wasn't that helpful. But it was so onerous because of the accumulation of the interest and penalties that she just had to give back the account, and that's kind of the outcome unless there's significant assets. And of course, for people with more significant assets, they typically have more service providers. So you'll see that with just individuals who move around or open up an account.
And just also with the tax exchange information now on these John Doe summonses, if your clients have a wallet and a foreign exchange, it's a good likelihood, if it's a mainstream exchange, the IRS is going to have the information relating to them owning those assets. And if they fail to disclose it on their 1040 each year and check the box and file the FBARs and other things, they're going to have an issue over time.
Oh, it's going to happen now because it's going to trigger it. We've got about 10 minutes. Let's see what we got left here. Oh, great. Yeah.
So a lot of individuals, as part of their asset protection, will utilize, cryptocurrency as part of that protection. The idea being that, how do I collect it, right? Like, I have a judgment, I want to go get it. Not only do you have a foreign trust, but you also have a type of asset without the keys.
Yeah, we used to have a piece of that paper printed.
Yeah.
And so, right, without the keys. So if Interestingly, we pose this academically, and I think a few of the clients have actually done it, where we have a foreign trust and we have a Bitcoin account. And the Bitcoin account, you can see there, I'm glad we had that slide there, because it shows your public wallet and your private wallet, which is kind of like the public can see the public number, but not the private number. And so what if you took the private number, which allows for the withdrawal of funds, and you tore it in half, right? And you gave half to the trustee, and you didn't have that half. I'm speaking hypothetically here, because I don't know if anyone's really done it, but it's academically very interesting. Kind of makes the point. So this is on a clear day. The client gets sued. Go through the litigation process. Takes a year. They lose. There's a judgment against them, and they get to the deposition. They are asked these questions on collection. And they have a house which can't be collected against. They have an annuity. They have whatever, 401k, nothing available to the creditor. Nothing available, except they have $4 million in a foreign trust, most of which is held in Bitcoin, depending on what its value is that day. They say, I've got half of the private key. You need the private key to access deposits. The other half is with the trustee. The trustee's offshore. The trust is offshore, and there's no jurisdictional connection. So what are the options at that point for the plaintiff, the creditor? Well, there are a few options. Okay, they go into court. Now, of course, we're saying the debtor didn't go bankrupt. Okay, now, out of bankruptcy court, we're in Florida civil court. There's no fraudulent transfer. This all occurred long before the problem. They go to court and they say, well, we're owed the $4 million, and the debtor has the $4 million in an account in Bitcoin in a foreign trust. And what the plaintiff can argue is that those funds should be brought back to the court, right, for collection. And if the defendant doesn't bring them back by demand of the court, that individual should be put in jail until they disgorge. Interesting argument. You can be put in jail for civil contempt. A lot of people don't understand that. Criminal contempt is when you actually, you did something, you made a crime, did a crime. Civil contempt is you're ignoring the demands of the court, and those demands comply with the law, etc. Of course, you can appeal this. So,
As you sit in jail.
So, well, yeah, as you sit in jail. That's right. So if this is rare, this has happened in a case, essentially in two fraudulent transfer cases. One was called Lawrence, and one was called Anderson. And so these cases basically where someone had a huge amount of money, ill-gotten gains, and they moved it offshore really fast. And the court said, one was a bankruptcy court, said, I'm putting you in jail until you disgorge that money. I want that money. You're paying your creditor. In one case, it was bankruptcy, so it kind of can convert to a crime, to a fraud crime in bankruptcy, which is another reason not to go bankrupt. And the debtor sat in jail for 6 years, but did not have to give up the money. In Anderson, that was a complicated case, but what happened was the actual plaintiff was a government entity, because you can imagine trying to collect on this stuff is outrageously expensive. and actually went to the Cook Islands to collect. The Cook Islands had a weakness in their statute, and they ended up changing the statute. And the Andersons got out in about 6 months and paid pennies on the dollar. There are cases, it's a different seminar where that has worked. There's a couple of SEC cases, but these are bad actors we're talking about, where they stole money or they just graft or whatever. And, the person's just not suited to go to jail and kind of collapses and writes a check. That does happen. But that's kind of what you come down to. But we find it's really, if you plan before the fact, basically doesn't happen. The foreign trust works, the U.S. trust works which works in the majority of cases, and the foreign LLC works well. We just want to do it on a clear day.
And then by adding the crypto on top of that with a divided key, can even offer another level of protection above, at least for that asset. They can't access it if you divide up the key, and it's
well. What you say, actually, it's not an access, because that's what Lawrence argued.
Right, but even if they got access, I'm saying it's a combination of, it's for some reason if they had a weak statute.
No, but if you actually don't know the other half, if the trustee actually is the one who has the other half, and the defendant, the debtor, actually doesn't have it.
Actually doesn't have it.
Yeah, actually, the trustee won't give it up, and the collection's impossible. That was the idea of this ripped Bitcoin wallet.
Which I think it makes sense. It's a strong argument.
Academically, I haven't seen a lot of that, but it's academically should work pretty well. We have a couple of minutes. Let's see what we got left here, because here we go.
And along with that, if a foreign trust acquires these assets, it's offshore, but then of course with Coinbase now, they're going to have information that the foreign trustee, the U.S. owner, owns these assets. But again, another step potentially to help protect the asset. And the same, if you want to do an ICO offshore using a foreign trust, we have clients that haven't thought about that. But again, you still have the Howey test, things like that to be aware. You're going to sell them in the U.S. Selling things in the U.S. are going to be regulated by U.S. things. Things offshore are going to be different. And
we had that. You had a couple planning. We've had a couple planning matters.
I did. It's complicated, but the idea being, if you do it in the market offshore, then the rules sort of the Wild West, as opposed to the U.S., which is more. This is what we do, and why.
Yeah, while you're offshore, it's much easier to plan.
Much easier, and the same thing with peer-to-peer trading with stuff. The idea being, people think that they're able to. If you have a non-resident, non-citizen with a foreign trust, then those exchanges for U.S. income taxes, they're not U.S. assets, aren't taxable.
Right.
They're offshore.
Right. If you're non-U.S.
So that's another way to utilize the instrument in a way to where.
Mm-hmm. And if you have someone coming into the U.S., you can deal in those assets.
Right.
There's no tax to the U.S. recipient even on those assets. You can deal in those assets without this wildly encumbering gift tax if you've got very wealthy people. So when we close up, we have a minute or so. We want to look at the whole structure. Do they have the Bitcoin? Do they have other assets? Are they U.S.? Are they foreign? Do they want to come in? Do they not want to come in? Right? If they don't want to come in, do we use a foreign blocking entity? Usually, yes. Right? If they want to come in, do we drop the assets into a foreign trust? Almost like an estate planning move, but also to keep the assets out of the estate and gift tax once they come into the country.
Right.
You know what I mean?
No.
Because once it's out and it's in the trust, a lot of times we use that as a trustee, and that has implications and directions upon their death, but no tax. Right. So we do that? Do we? Under the trust, we tend to have all kinds of different assets. We want to segregate those assets. What if someone falls on a property? We want to make sure that doesn't spill over to other properties. And so we're going to come up on the.
Yeah, I just wanted to emphasize one last thing. When you have clients that are dealing or acquire or investing in a cryptocurrency, as their professional who's giving them advice, we would recommend that you explain to them that, one, this is a unique asset, there are pluses and minuses, but if you're going to do it, that's fine. But make sure you keep very good records, because you need to be able to substantiate when you obtained it and what the basis of these assets are. Because we've seen on the other side, when they have not done that and the IRS comes knocking, you can't substantiate zero. Plus, potentially where these exchanges are located, all these different things. Make sure that you at least advise them. If they don't do it, they don't do it. We've never had that happen before, right? We advise our clients to do X, Y, Z, and they don't do it. But at least we've done our job. And we've explained to them, what the potential pitfalls are. So if something turns bad later, they can come back and say, well, so-and-so didn't tell me.
Yeah, a lot of times with the CPA really really covers himself with respect to the team. The CPA has a wealthy client. The CPA has recommended a competent financial advisor, competent attorney. If there's other consulting that has to go on, the CPA creates the team. You have that in writing. That goes a long, long way. I can't tell you how many times CPAs have come in with audit issues and tax issues where they didn't have an engagement and they haven't recommended the team. If you have the engagement, it limits your exposure with respect to exactly what you're going to provide the client and nothing more. And if you've recommended the team, it just reinforces the fact that you're not going to do that stuff. Right? So our information is on this last slide. Please contact either Brian or I, and you can email either of us with any questions or comments if anything comes up. I've also written a book on the asset protection structuring and on the foreign tax from the estate and gift tax. And if you want a copy of the book, we've got it in a more summary format for financial experts like yourselves. And we also do have a law school book with the cases. A lot of the CPAs actually go for the law school book, funny enough. But that concludes our presentation. We really appreciate you attending.